Good afternoon, everyone. This is Class 3 of Foreign Legal Materials. So in the first two classes, we talked about an introduction and overview of international human rights, and we looked at the United Nations system, the international system for administering and enforcing human rights. So for these next two classes, we're going to look at the two major categories of human rights: civil and political rights and economic and social rights. These are the two major categories of human rights. And then there are other human rights we'll talk about after that, which come from specific treaties, like Treaty for Women's Rights, Children's Rights, Migrant Rights, lots of different issues. But even these often usually refer to the two major categories of civil and political rights and economic and social rights. So today we're talking about civil and political rights. You'll see here is the image of the slides we're going to use for today. You can get these slides off of the Learning Management Center, so please get these slides so you can follow along with the class, and you can even print them out and make notes on them or something, or take notes while we're going through that. All right. So the first thing to know about any human right, which we talked about in the first class, is all human rights need to have a source. So the two major sources needs to have a legal source, and we talked about the two major legal sources in the first class. There's treaty law, there's treaties, and then there's customary international law. And we said that treaties are a document that states sign, and then they actually write the law down into a document, and they'll take that back to their legislature or whatever system they use and adopt it into law, and that ratifies it. That makes it law for that country. That's a treaty. And then we talked about another category of customary international law that's not written down, but states still need to follow it. And there's two requirements for customary international law. One is state practice. The state has to actually follow the rules. And two, the state has to follow it out of a legal obligation. And the state will express, usually in these cases, the state will actually express itself, we're following this out of a legal obligation. So if the state is practicing it, following the law, and they express it's out of a legal obligation, that makes it customary international law. So our first question when we look at civil and political rights is, what's the legal source? So the source is what makes it international law. And then up here at the top of this first slide, we'll see the two sources. We have the Universal Declaration of Human Rights, passed in 1948. And this is not a treaty. This is a declaration. And then we have the Universal Covenant on Civil and Political Rights, called the ICCPR. So this ICCPR, this is actually a treaty. It was passed in 1966. It didn't actually become law until sometime in the 1970s. 30 parties, something like 30 parties have to join the treaty first, and then it becomes a law. And it took about, over 10 years for 30 parties to join it. But today we see there's 173 parties. And then in this list down here, we see countries that have not joined that treaty. In Asia, we see Bhutan and China and Malaysia, Myanmar, North Korea, are countries that have not joined this treaty. Of course, they still need to follow civil and political rights, but not as treaty law, so then we have to use customary international law. So that's where the Universal Declaration comes in hand. The rules in the Universal Declaration of Human Rights are generally considered to be customary international law. They're customary international law not because it's written down. Remember, that's a treaty, and this is not a treaty. States did not ratify this. But states generally practice the rules of the Universal Declaration, and they will express and say that these are rules of legal obligations in their expressions. So if you're a country like Malaysia or China and you break a civil and political right, and if a country like China or Malaysia breaks a rule of civil and political rights and you want to comment on that and say that was a violation, to do that, you would say not that it's a violation of the ICCPR because they're not a member of the ICCPR. You would need to say they violated the rule under the Universal Declaration of Human Rights. You would formally say they have violated the customary international law that defines the civil and political rights, and we know those rules from the Universal Declaration. These represent the customary international law for civil and political rights. So generally, it doesn't often make too much difference because the ICCPR and Universal Declaration of Human Rights, they overlap a lot. So if you see a rule in the International Covenant, you'll have the same rule generally in the Universal Declaration. But sometimes they're a little different, and that's where things can get a little crazy. So if you want to comment on a state that violates a right, you need to you might not be able to use, you can't use the text from the International Covenant on Civil and Political Rights by itself. You have to say it comes from customary international law. And you're safer generally using the Universal Declaration rule for that. So let me give you an example where the Universal Declaration and ICCPR can actually be a little different. This is the case with the right to have a lawyer. So when someone's arrested, there's a civil and political right when a country arrests someone that they have a right to a lawyer. They can talk to a lawyer of their own choosing before the trial to know what their options are, and during the trial have a lawyer represent them too. But in some countries, so we did a report on China. So China has a practice sometimes where it will arrest people and hold them for a long time, sometimes up to a year before they have the trial. And when they do this, this is called incommunicado. They're not allowed to talk to anybody, and that's called incommunicado. So there's different reasons that we can talk about later why China will hold someone for up to a year before they have a trial, and they're not allowed to talk to anyone. But one important part of that is they can't talk to a lawyer. So they don't have access to a lawyer during that time. And that looks like a civil and political right violation because we should have a right to a lawyer. But as we see on this list, China is not a member of the ICCPR, so we should use the rule from the Universal Declaration. So let me give you an example of how the sources can be a little different depending on whether you're using the ICCPR or Universal Declaration. And this is just a general story about sources. The point about a legal source is you need to use the text you have. You can't make up a law. You can't make up the boundaries of a law or the definition of a law because that's, what you like. You need to use the text that the source gives you. So that's what this lesson is teaching us. So let's look at these two documents. Let's look at a country like Japan is a member of the ICCPR. So let's look at a case. It's not likely that someone doesn't have access to a lawyer, but you can imagine a case if it does, and the person wants to find a violation. Here's the ICCPR text. So this is ICCPR. So on the Learning Management Center, on that list of files, you'll find this document. So please download this too. And so anytime we look at any rule, make sure you use the rule from this text. This is the actual treaty document for the ICCPR. And so the rule for access to a lawyer is going to be Article 14. So we're going to zoom down here to Article 14. Here it is, Article 14. So Article 14 is about rules, with courts and tribunals. When people are arrested, they have a right to certain things when they have a trial. And so there's a specific rule for lawyers, and it's paragraph 3. So Article 14, paragraph 3, in the determination of any charge against them, everyone shall be entitled to the following minimum guarantees. So everybody, when there's a trial, needs to have these minimum guarantees. And in B, so Article 14, 3b, we see to have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. Counsel is another word for lawyer. So this is the right to have access to a lawyer. A person can communicate with a lawyer, and then of their own choosing. Of their own choosing means the government doesn't appoint them a lawyer, because when the government just gives you a lawyer, you can't trust that that lawyer is on your side. That lawyer may just be acting to protect the state and not you. So you need to be able to choose your own lawyer. All right, so that's the ICCPR rule. But if we have this case in China where someone doesn't have access to a lawyer, if we use this text, China may complain, but we're not a member of the ICCPR. So why should we be bound? We're not bound by this treaty. So then we want to use customary international law. So that the safer way to represent customary international law is the Universal Declaration. And here's the text of the Universal Declaration. I'm going to put this online too. This is Article 11. let's read what Article 11 says. The text is a little different. So we just saw in ICCPR Article 14.3b, people have a right to communicate with the council of your own choosing. That was the text they have. What do we have in Article 11? So this is everyone charged with a penal offense has a right to be presumed innocent until proven guilty, and then at a public trial in which he has all the guarantees necessary for his defense. And then this other text is about other issues, other rights, but this is the one that we're going to look at. It doesn't mention a lawyer, it doesn't mention counsel. It says all the guarantees necessary for his defense. So here's a point for you to let's have a bit of thinking time. So think to yourself, if you want to accuse China of breaking a civil and political right of access to a lawyer, and this is the text we have. We don't have the direct text, access to a lawyer. The ICCPR has that text. You have the right to communicate with counsel of your own choosing. But in the civil and political, but in the Universal Declaration we see here in Article 11, it doesn't say that. It says you have all the guarantees necessary for your defense. So what's an argument you could use? You can stop the video even and think to yourself, what's an argument you could use that use this text to say someone has a right to a lawyer? So let me give you a few seconds, stop the video, think about it, and then start it again and let's talk about it. Okay, so the argument is really simple. You need to argue that a guarantee that having access to a lawyer is necessary for one's defense. And to really argue that well, you have to argue if you didn't have a lawyer, you wouldn't have a fair defense. So if you can't have a fair defense, then without a lawyer, then it must be necessary. So if you're going to accuse China of a country like that, or any country that doesn't allow access to a lawyer in a trial or before it, but they're not a member of the ICCPR, we need to use this text and we need to argue they didn't have access to a lawyer, and that's necessary for your defense and that makes it a civil and political right obligation under customary international law under Article 11, represented by Article 11 of the Universal Declaration of Human Rights. That's how you would argue that in that case. Okay, so I hope you understood that. That could be a little confusing, but just remember, you always have to use the text in the source you get. You don't get to make up your human right. You have to use what the source actually gives you, and you need to look at the language, because sometimes the language is it might not be exactly what you think. It might be a little different, and you need to use the language you have to argue for a right. Okay. So, but for most other countries, we can just use the ICCPR text directly. So that's the legal source for civil and political rights. Okay, so I already mentioned in the first class that civil and political rights and economic and social rights are a little different. These are these two big categories. What's the difference? Why? So the Universal Declaration of Human Rights combined civil and political rights and economic and social rights into one document. But when they decided to make it two treaties in the 1960s, they separated these two into two different treaties. So you may be asking, why did they separate them? So there's two basic reasons that's explained here why they were split into two treaties. So one, at the time, this was the 1960s, this was during the Cold War. So in the Cold War, you had the Soviet Union, and you had the Soviet Union and the Communist Bloc, and you had the United States and England and France and the liberal Western Bloc democracies. And these two countries, the Western Bloc at the time really privileged civil and political rights, and the Communist Bloc really privileged economic and social rights. So that's one reason they were separated, because some of the Soviet Union wanted to join the economic and social rights, but not the civil and political rights, and maybe there were some countries that were the opposite way. And that has to also do with the major difference that we're going to get to in this list down here, and you'll see why there's that difference of opinion. But even aside from that, the Cold War is over now, but there's still a good reason to separate them even today, and that's because the administration of them is different. They're different kinds of human rights. And one major difference is between immediate rights and progressive development rights. The way you administer them. So many civil, CP stands for civil and political, ES stands for economic and social. So a lot of civil and political rights are immediate rights. That means the violation happens immediately. So if you look at something like the right to speech, if the government arrests you for the speech, the violation happens immediately as soon as they arrest you. Or if they censor your book, you write an article and they don't allow it to be published, that's censorship. The second they make that decision, it's immediately a violation. That's an immediate right. Whereas many economic and social rights, like the right to health, is progressive development. That means it can take years or even decades where you're gradually making more progress on the right. So for the right to health, that has to do with things like building schools and hospitals in your country. And it can take years to build a hospital or have a school in every part of your country. So they're administered. So that difference also has to do with how they're administered. An immediate right, that's an immediate violation. You can have the trial right then. As soon as the violation happened, you can make a complaint and have a process to deal with it immediately. Whereas progressive development, if you're having a development of a human right over many, many years or decades, you need to invest a lot of time in it. It's not clear when exactly the violation happens over these many years. They're just administered quite differently. So that's a good reason why they're separated. Let's look at some of the other differences. So generally, the civil and political rights are about protecting people from persecution from the government due to differences and to promote and to protect, well, let me just read this. To protect people from persecution due to their differences and protect public and private spaces. So this is generally people being punished or discriminated, and often because they're differences. They believe something different, or they're a different race or a different gender, and they're being punished for that. There's something different about them. Civil and political rights are protecting them. So when we talked about freedom of speech again, the government wants to censor that or punish speech it doesn't like because it doesn't like what you believe, so it's punishing you for it. That makes it like a civil and political right. And then economic and social rights are generally about providing a minimum standard of living. So things like having enough food to eat, having good schools, good health care, that's economic and social rights. And generally there's a difference between these two you can already think about is who does the violations. So generally, in civil and political rights, the government is often the source of the harm. If you're being censored or arrested, because the government doesn't like what you believe or it doesn't like your racial group, the government is the one committing the violation. The government is the one arresting you arbitrarily. The government is the one censoring you or persecuting you. So in these cases, the government's usually the bad guy. It's the main source of the harm that we need to protect. Other people can cause the harms too, but even then, the government isn't protecting you from those other people. Okay. Whereas with economic and social rights, if we're talking about building hospitals and schools, the government's usually the main source of protection. And this is we talked a little about in the first class. Remember the difference between duty to respect rights, you need to stop violations yourself, and duty to fulfill rights. The government needs to take proactive action to protect the right. Many economic and social rights are duty to fulfill rights. The government's the good guy. He needs to take proactive action to take care of these. Whereas with civil and political rights, the government's usually the bad guy. They're the ones committing the violations or not protecting you from other people committing the violations. And then here's what we just said. Most civil and political rights are immediate. That means as soon as you're arrested, the violation happens immediately. That the second the decision's made. Whereas many economic and social rights are progressively realized over many years. So it's your protection of health of a country, a country's protection of health in that country or education gets better and better over time. They have a duty to make progress. And we'll talk about that in the next class. But it's not always an immediate violation. All right. So a lot of the duty for civil and political rights are often negative rights. It means stop. Don't do that. If the government does nothing, it just allows you to speak and doesn't do anything to stop you, it doesn't punish you, then it's protecting the right. These are called negative rights. It means stop, don't do it. Whereas many economic and social rights are positive rights, which means you have to do something. if you don't do anything, that's a violation. You need to provide education. You need to provide health care. These are active things you have to do. So this isn't strict. So there are some civil and political rights that are positive rights, where access to a lawyer is one. Sometimes if people can't afford a lawyer, the state needs to provide a lawyer. So that's a positive duty, something positive. If the government didn't do anything, that would still be a violation, even though it's a civil and political right. And there's some economic and social rights that are negative, where the government should stop doing something. So this isn't always strict, but this is just generally, just a general guidance. A lot of them are like that. Some civil and political rights can be restricted, and some can't. And it's very developed. There's been a lot of cases. So there's a lot of cases on civil and political rights. And when there's a lot of cases, that means the law is very developed. When we have a new case, we can look at the old cases and learn how to deal with them by looking at the old cases. With economic and social rights, it's much less clear whether restrictions can happen or not. And also, there's not many cases. Cases don't go to trial for economic and social rights, so we don't have as much guidance with when's a violation happen and what should we do. So we're going to talk about this next week, but today's class we're going to talk a lot about when the government can restrict a right, when it can't, and how that's done in actual cases. All right, and then back to our first class, we already said, both civil and political rights and economic and social rights are considered indivisible, interdependent, and universal. And here's the legal source for that, by the way. There's a Vienna Declaration, paragraph 5. So that's considered customary international law. But anyway, indivisible, interdependent, and universal. So all of these human rights have equal status. They're all the same. They're all independent human rights. They're all universal human rights, but civil and political rights work differently than economic and social rights. Okay, so let's look at what are the types of human rights. What are civil and political rights? So generally, we already said here, generally to protect people from persecution because of their differences. So that's what this says here. Generally, the ICCPR protects people from government persecution of individuals because of their differences, and it protects public and private spaces. So there are 3 general types of rights, and then we have, so here are the 3 general types of rights, and then we have 4 categories of rights. So we have civil rights, civil and political rights, and then we'll talk about this difference between public participation and public spaces and private spaces. Okay, so a civil right, this goes back to the first generation human rights, when civil right is basically its rights as humans or citizens in a country against government punishment. So civil right means the government is limited in its power. When this is what happened in this 18th century, when they first started talking about human rights, there was a theory that, under the feudal, medieval system, the king, or, here in Japan, the shogun, whatever, the emperor, has ultimate power, and they have, limitless power. And then what came with liberal government, this thinking from the 18th century, is that actually governments are limited in their power, and they're limited based on civil rights. So the government can't do certain things that violates people's rights, and these are called civil rights. So a lot of it's like arbitrary punishment. So things like the government can't just kill people. It can't torture people. It can't put them in slavery. It can't discriminate them. They need to have a fair trial, and you shouldn't just punish them. So these are rights you have against government persecution. A government attacking you for being different or for whatever reason. Limits against government abuse. These are called civil rights. So that's the first thing civil and political rights are. Then we have public spaces and private spaces. That's what it said here. It protects public and private spaces. So public spaces are a public place where people can participate in the public debate. They can participate in public life. Public life includes all sorts of things that people do as a society-wide. So things like, it means participating in government. You can vote, you can run for office. But other public spaces like freedom of speech is really about you can express your opinion to the public. We're talking about these public issues that are important to everybody. I want to be able to say something about it to the public so we can have this public conversation. So civil and political rights are protecting this public space for people to participate in society. So that's what this says, political rights, right to protect full participation in civil society. So we can do that by voting. Some of these are for citizens and some are for citizens and foreigners. Of course, the right to vote is just for citizens, not for aliens, foreigners. But the right to speech is for foreigners and citizens, and that's to participate. Assembly, having a group that comes together to have a demonstration. Association, being a member of a party. A public belief. So if you're a member of a public, if you're a member of a religion like Buddhism or Christianity, and you want to participate in that, that's a kind of public space too. Okay, and then protecting democratic and civil society space. People saying and doing what they want to participate in public social life. That's public space. And then we have private rights. So civil and political rights. Sometimes you can be punished not for what you say publicly, but for who you are privately. So civil and political rights also protects private life. That includes privacy. So what you do inside your home, the government shouldn't surveillance it. If you have private information, the government shouldn't give it out. That's the opposite of the public space. That's information you have inside into your private space, and you want to protect that. Protections for your family, for children. Some can be, so a lot of these categories can go into both of them. So again, like protection of religion or belief, that's not only the public participating publicly in that religion, like that church or that temple, but religion and belief is also a private belief. So it's also protecting what you believe privately and can include private expression. So freedom of speech, you can do freedom of speech for public reasons and private reasons. So publicly, you do speech, because we want to talk about this issue in this issue that's important to us all in the public, but you also, things like being able to change your hair into a different color or wear the clothes you want to wear. That's a kind of freedom of expression too. You're not doing that to participate in a public debate. You may want blue hair and a crazy shirt, clothes, because that's your private expression. That's who you are as an individual. So civil and political rights also protects this private space for you to express yourself as an individual, for you to believe what you want to believe privately, even if you don't tell anyone. You can't be punished for that. And some associations and assemblies, some gatherings you get to aren't for public, they're for private use. So, there's like private groups too you can join. Okay, so what are the categories of rights? That's what this list is. So the first we have is the right to physical integrity. So in some ways, these are different ways the government can punish you. So one way is the government breaks your physical integrity. It can actually physically harm you. So that's physical integrity. So that's the right. These are Articles 6 through 8. So right to life, the government can't kill you. No torture, the government can't torture you or beat you up. No slavery, the government can't put you where you have to work and be owned as property. So that's physical integrity. The government, aside from physically harming you or taking, your physical integrity, that could also include mental illness too. If they do something to mentally harm you, that's considered integrity too. But they can also take away your liberty. They don't, they put you in jail, they arrest you or detention, or they don't allow you to do certain things. That's liberty and security of person. That's Articles 9 through 11. So so you have a right to liberty, no arbitrary arrest. The government has to have a good reason to arrest you. If you sign you can't be punished for a contract. Basically, you can do certain things. The government can't limit your, they can't arrest you or detain you or take away your liberty. Okay, then we have procedural fairness and rights of the accused. So this is Article 14, which we already looked at in that access to a lawyer case. And remember, in the first class, we talked about procedural rights. Remember, procedural rights it doesn't tell you what the answer at the end is. It just tells you the process to get you to an answer has to be fair. So in a trial, you can still be found guilty, but the process to find you guilty needs to be a fair process. You need to have access to a lawyer, you need to have evidence against you, things like that. So this is civil and political rights, procedural fairness. So these are rights in trials and in law. So when you have a trial, you need to have certain procedures that are fair in that trial. So that's also civil and political rights. And then we have what are just called individual liberties. So these are specific categories of things people do that are considered civil and political rights. Articles 12 through 27, there's a long list of them. And then here's just a list, here's a basic list. Freedom of movement, you can move around the country wherever you want and the government can't stop you. Isn't supposed to as a civil and political right. You can believe what you want to believe. You can, freedom of expression, you can say what you want to say. Assembly, you can come together in a group with who you want to. Association, you can be a member of a party. Okay. And then inside these individual liberties, you can maybe define 3 subcategories. So a lot of them are just liberties, speech, assembly, association, movement, and belief. These are things that you can do, that individuals can do, that's protected. Then here's again public and private. So private life are things you can do in private that should be protected. So that's again the right to privacy. You can do things inside your own home that the government shouldn't make the information public or shouldn't surveillance you. And there's rights for the family and children, so domestic life inside your home. So that's civil and political rights. Here are the articles in the ICCPR. And then political rights, that's again, that's actually participating in government. Here are the articles in the ICCPR where it is the right to vote, the right to participate, the right to run for office, to be elected, and non-discrimination. So the laws all have to, not discriminate who you are for political life. Okay, so that's a really broad interview of civil and political rights, the different categories. A lot of these we're going to look at in future classes, but we're going to talk about some of these in this class. So we just said these are the civil and political rights. What does the government have to do to protect them? What's the obligation? So remember, with any law, we said this right from the first class, the government has to do something, or has to not, has to abstain, stop doing something. That's the obligation. If it's not an obligation, it's not a law. So what's the obligation? What does the government have to do? So the main basic obligation is this ICCPR Article 2.1. We can actually go to the ICCPR text. Let's look at the ICCPR text and look at Article 2.1. So remember with all of these, here's Article 2.1. Article 2.1, each state party to the present convention undertakes to respect and ensure all individuals within its territory or subject to its jurisdiction the rights recognized in this convention. So undertake to respect and to ensure. So we're going to really focus on this word to respect. So, which we mentioned in the first class, the duty to respect. So all of these rights listed in that, the government has the duty to respect these rights and to ensure them. To ensure is another way to say to protect them. And we said already in the first class, remember the difference between duty to respect and duty to protect. Duty to respect means the government itself doesn't violate the right. So that means, a lot of violations for a lot of civil and political rights often come from security forces. Here's a picture of an assembly. Here's an assembly, and here we see the police. So the police are maybe, if they get violent or they might try to break up this assembly, if they do that arbitrarily, that might be a violation. So the duty to respect is the government stops itself. It stops its own police. It stops its own military from violating these rights. That's the duty to respect. If some private group were trying to stop this, and the government should try to stop them, that's the duty to protect the right. Okay, but the main basic one is the duty to respect. The government has the main duty to respect all civil and political rights in its own conduct. And where does it have to do it? In Article 2.1, we read inside the territory. Actually, if we were really specific, let's look again at that text. The text again was in the territory or jurisdiction, within its territory or subject to its jurisdiction. Can you see that? within its territory or subject to its jurisdiction. So that's the actual text we get. So that means everybody inside the territory, the territory of Japan, including foreigners. Jurisdiction's an interesting one. There might be, you might have jurisdiction, for example, America has jurisdiction over bases that are not in its territory. So, where it's using its power, areas where it uses its power, it also needs to protect these rights. Is there a duty to protect rights? So definitely, it didn't use the word protect, it used the word ensure. But does it have to stop? Does this treaty mean the government has to stop private people from violating this right? So as we mentioned in the last class, remember the international system? Every treaty has a treaty body that will give commentary, how to interpret it. So the treaty body for the ICCPR is called the Human Rights Committee. And this is the abbreviation for it. So the Human Rights Committee, it actually gave an authoritative statement interpreting, and it says that the government must protect rights in areas amenable to application between private people. So that means some of these rights are amenable. It means it's easy to apply them to private people, but some rights it's not easy to apply to private people. Like again, the right to a fair trial. That's not really a good fit because governments are the ones that hold trials, so they need to respect the right. But private people aren't really holding trials, so the right to a fair trial and the right to access to a lawyer is not really amenable to application to private people. But other rights, the freedom of expression maybe, or freedom of movement, private people might be able to stop those, and if they do, that's amenable to applying to private people. The government needs to stop violations from that. So that's the term we used if it applies for protect rights. Here are some examples. Right to life. So, of course, private people can kill you. Privacy. Another private person can invade your private life, family life, where private people are involved. Definitely, we can. The government will have a duty to protect. It'll have a duty to stop private people from violating that. Another duty that the ICCPR gives is if there's a violation, the states must provide effective remedies, so that actually address the victim's issues. So the word the ICCPR uses is effective remedies. So the government can't just give any remedy. The remedy has to be effective to actually help stop. Has to actually stop the violation, and maybe give them some compensation. And address the victim's issues. If they've been harmed, maybe rehabilitation, like pay for the medical bills, and definitely ensure that the violation doesn't happen again in the future. So these are so the state has a legal obligation under the ICCPR to provide an effective remedy. Actually, if we go to the ICCPR text and want to know the where that's for effective. So there we see Article 2A, an effective remedy. So each state of the party present convention undertakes to ensure that any person who's been violated has an effective remedy. Okay, so that's Article 2, 3A. So that's the duty to an effective remedy. Okay. All right. So, can the government restrict a civil and political rights? So they can sometimes. Of course, sometimes the government, takes down a video or stops speech. But there's two questions. There's a question we asked before. So there's two basic categories of civil and political rights. Ones you can limit. Ones the government is allowed to limit sometimes. In an emergency or when it's necessary, and cases when the government can never restrict it, even during an emergency. We mentioned in the first class Yas Kojin's rights, like the duty, torture, not to commit torture. That's Yas Kojin's. That means the government can never torture someone, even in an emergency. So the first question we ask is it non? Whoops, that's an error. So this non should not be here. So if it's derogable or if it's non-derogable or derogable. So I'm going to have to erase this non. So slides 6 through 11 are about derogable rights, and slide 5 is about non-derogable rights. I'm going to fix this before you get this, but just note that this word is supposed to be derogable, and this non here was a mistake that I made. Sorry. Okay, so we're going to look at first slide 5. That's the next slide, about non-derogable rights. Derogable is another word for limit. So slide 5 is rights you can never limit, even during an emergency, and slides 6 through 10 are derogable rights you can limit sometimes. So we have two different terms here, yes cogents and non-derogable. Non-derogable means, the main difference is non-derogable means the treaty says you can't restrict this right. And yes cogents just means it's as a matter of customary law. Even if a treaty says you can restrict this right, you still can't restrict it. So, the right to torture again. The right, you can't commit torture is yes cogents. You can never torture, even during an emergency. But even if you passed a treaty that says you can sometimes torture someone, you still can't because it's yes cogents. Non-derogable just means the treaty says you can't restrict this right. But basically they mean about the same thing. So to derogate means, again, to restrict the right. The government doesn't want to follow this right. It has some good reason to violate this right, to suspend this right or restrict it. And so for some rights, you must always follow a right, and you can never derogate it. And these are called non-derogable when the treaty tells you you can't restrict it. And yes cogents when customary international law is telling you you can't. Yes cogents is Latin for compelling law. Okay, so in the ICCPR, it actually gives a list of non-derogable rights. And this is them. This is the list. So basically, I didn't put the articles. Maybe I'll put the articles to them later. But right to life, freedom from torture, cruel, inhuman, or degrading treatment, freedom from slavery, freedom from being imprisoned for a contract, if you violate a contract, freedom from retroactive criminal laws. Criminal laws applying after you pass the law, you apply them to behavior in the past, recognition as a person before the law, and freedom of belief, which we're going to talk a little about later. So these rights the state can never restrict. So when you see a case study, when you see a case, the government has restricted your right. And it's a civil and political right. Your first question needs to be: is it a derogable right or is it non-derogable? Is the state allowed to restrict it, derogable, or is the state never allowed to restrict it, non-derogable? And this is our analysis. That's your first question. So if the state tortures someone, your first question is the freedom from torture derogable or non-derogable? So here's the list of non-derogable, and we see freedom from torture. So if it's freedom from torture, that means the state can never do it, even if it's an emergency. So our analysis is finished. If our right is non-derogable, which means the state can never restrict it, then your analysis is over. The state has tortured someone. Torture is a non-derogable right. They're never allowed to do that, even if they say they have a good reason. So our analysis is finished. They can't do it. So that makes, if you see a question, when we do our case notes, if you see a question where someone violates a non-derogable right, any right on this list, all you need to say is that's non-derogable, it's a violation. The state can never restrict it. So the state has violated it, analysis is finished because it's on this list. Okay. But other rights may be restricted if necessary and proportional to meet legitimate ends. So now we're going to look at derogable rights. So these are limits to civil and political rights. So this is the list of non-derogable rights here. So basically every other right that's not on this list is derogable. Basically. So if you see any right, freedom of expression, freedom of assembly, freedom of association, right to privacy, all of these rights are not on that list before they're derogable. The state can sometimes restrict it. And then it can limit some in necessary cases. So ICCPR Article 4 tells us we can restrict it during emergencies. And the different articles for the specific rights, like Article 19 for freedom of expression, tells you how you can restrict it. But generally speaking, all the different rights usually have the same 4 conditions. They may differ a little. You need to, again, you should always look at the text, know the really specific cases when you can restrict a right. But most of them generally follow this 4 conditions. So we're going to look at these 4 conditions. When can the government restrict a right? So freedom of expression. The government wants to take down your video from YouTube or wants to censor your book. These are the conditions when it can do something like that. Freedom of expression is a derogable right. So the first one is legal. The limit must be based on a law, not an official's opinion. So when the government does restrict a right, that restriction needs to be provided for by law in advance. You can never have a police officer just decide right then, in his own opinion, we can restrict this right. It needs to be passed by a legislature. They need to pass a law saying exactly when you can restrict this right. And then here it says the law must be very specific. So the law just can't say sometimes when in a police officer's opinion they can restrict a right for public order. That's too general. That doesn't tell you when the specific cases you can restrict a right. It has to be very, very specific, exactly when you can restrict it. And it has to be written down in the law. So it's never just a person's opinion. So that's the first condition. The second one, it has to be for a legitimate purpose. So this is the government interest. It has to be able to protect a public interest. The 2 main legitimate purposes are a public interest or to protect the rights of others. So if someone's threatening to kill someone, person A is threatening to kill person B. Person B has a right to life, so the state can maybe restrict person A's behavior. They can restrict their rights to protect person B's rights that are more important. And then you can balance the 2 rights. The more important right should win. And then public interest. So right now, maybe with this state of emergency in Japan for this coronavirus, there may be some restrictions on movement for that or something like that. That's in the public interest for health. So that's a legitimate purpose. And then also, they need to be consistent with the goals of the ICCPR. Generally, it means you're restricting this right to protect someone, not to harm someone. So generally, if there's a right to be restricted, it needs to protect people, consistent with the goals of the ICCPR. And remember, the goals of the ICCPR are to protect people from being punished. So that's our second interest. Our second rule. The third one, necessary and proportional. So we're going to talk about that, but the government the restriction has to be necessary to meet this legitimate purpose. If you can meet this purpose in another way, it's not necessary, you can't do it. And not more than needed. So if there's a less restrictive way to do that, you can meet this without violating this right. There's another way to do it, you need to do it the other way. And non-discriminatory. The law has to apply the same to everybody. So you can't say we can restrict this right for this one, for women, but not for men. It needs to be applied to everyone, without discrimination. Okay, so let's look into a little more detail about how these rules work. So necessary and proportional analysis. The main test for necessity, we often use a but-for test, which means but for that restriction, the goal can't be done. So first the government decides the legitimate purpose. We want to protect B's life. And then this is the but for. But for stopping this person's video, let's use a case of a terrorist putting up a video telling his followers to kill people. So the government wants to take down this video to protect people's lives. So is it necessary? So the question is, but for putting down the video, this person would have been killed. That means if you hadn't taken down this video, then people would have been killed. That's how you know it's necessary. If you could stop this person from being killed without taking down this video, it's not necessary. You can't take it down. So that's called the but-for test of necessity. You have a cause and effect. The cause must cause, the effect is the goal. So to stop people from being killed, you must stop this video going online. Okay. And if there's multiple ways, if there's a small restriction, you don't actually take down the video, but you put up another video warning people not to listen, providing a counter story, something like that, a smaller restriction. If you have the option between a big restriction and a small restriction, and both of them will stop it, you have to pick the smaller restriction. You can't, this is called the least restrictive alternative. If there are 2 or more options ways to meet your goal, but one restricts the right less than the other. The state has to choose the least restrictive alternative, or the no restriction. So it can't do the restriction unless it's necessary. And then proportionality analysis. So proportionality means the government always has two, it's like a kind of scale. The government, there's two sides on the scale. So there's the government interest, the purpose. Remember in that terrorist case, it's to protect someone's life. And then there's the interest and then there's the right you're trying to protect, the burden on the right. You're taking down the video. Are they proportional to each other? So basically is the proportionality analysis is the burden on the right must be proportional to the government interest it's placed. So this is a picture of the government interest is this little ant, but the restriction on the right is this elephant. You can't have that. That's disproportional. So here's your method. First, you identify the burden on the right. Is it a big burden or is it a small burden? Are you stopping the speech? Are you completely stopping the speech? Or are you just adding some more information to the speech? That's a less restrictive one. So is it a big burden or a little burden? And then you identify the government interest. Is it a big interest or is it a little interest? And then you do assessment. The burden cannot be large if the interest is small. So if you have a big burden, you can't have a small interest. Let's look at an example. So in speech, if you censor someone, if you take down a video, that's censorship. That's the biggest burdens you can have in speech, is completely stopping it. And a small interest is you're not stopping it, but if there's a crowd and there's a speech out in the street, you can move the crowd around. So you're not stopping the speech, you're just moving the crowd off the streets to help protect traffic. That's a restriction on the expression, on the speech, but it's a small restriction. Okay, so you have a big restriction and a small restriction. And then the government interest. So if the government's saving someone's life, like this terrorist is making a video that's going to kill someone, if his followers are going to kill someone, protecting someone's life is a really big interest. And a small interest is, in that case of the speech out in the street, you're just protecting traffic flow. You're not stopping the speech. So that's a small interest, just helping traffic. Okay. So here's how it works. You have the government interest on this side and the burden on speech on this side. And the test is the burden cannot be heavier than the interest allows. So if we want to stop the speech, we're putting this big 5K going. It's going to go way down. If we're stopping a speech just to help traffic, this 1K, this small interest, is not going to be big enough. So you cannot stop speech just to help traffic flow. You cannot stop the entire speech because it will be lopsided. The burden is too heavy for the interest, and the interest is too small. But if you're saving someone's life, if you're taking down a terrorist video and his followers are going to follow it and kill people, you're saving someone's life. It's a big burden, true, but the interest is also a really big interest. You're saving someone's life. It's proportional. You're allowed to stop a speech completely if you're saving someone's life. And then usually moving something like a crowd, this small burden might not be enough to protect someone's life. You need this really big one. So if it's necessary, you can put a big restriction if it's necessary to meet a big interest. But you cannot use this big restriction for a small interest like helping traffic. But you are allowed to take a small restriction on the right, like putting barriers and getting people off the street and moving a crowd to help traffic. You're allowed to do this small burden on speech because it's a small interest. So it's proportional. So this restriction on speech, moving crowds on a street, is a small restriction, is proportional to the small interest of helping traffic. Stopping a speech, completely taking down a video, is a really big restriction. It's proportional to a big interest like saving someone's life, but a big restriction like stopping a speech is not proportional to a small interest like helping traffic flow. You cannot stop a whole speech. Okay, so that's proportionality analysis. So that in a nutshell is how civil and political rights work. First, you ask yourself, is it a derogable right? Is it non-derogable? We can never violate it. Or is it a derogable right? We're allowed to restrict it. If it's non-derogable, your analysis is over. The government can't do it. If it's derogable, we look at these 4 conditions. Is it legal by law? What's the government interest? And then we do, is it legal and non-discriminatory? So is it legal? Is it written by law, and does it apply the same to everybody? If so, then we go to necessary and proportional analysis. Is it necessary? Must the government do this to meet its interest? Is the interest legitimate? Is it protecting the public interest or the rights of others? If it's legitimate, then is it necessary to meet? Is the restriction necessary to meet that legitimate interest? And is it proportional? So if we have a big restriction, is that big restriction proportional to this interest of the government trying to protect someone? And if the interest is just as big as the burden, it's proportional. The government's allowed to do that, but not if it's disproportional. Okay, and here's some information for scope and purposes of limits. So here's just some more information about how when governments restrict rights, what makes it proportional. So one is arbitrary. So a government's restriction won't be legitimate if it's arbitrary. So here are some conditions of arbitrariness. For example, if it's illegal, the government can't do anything that breaks its own law. Based on the will of a decider, not by law. So if you have an individual official that just says it in his opinion, he restricts a right, that's arbitrary. If it's unreasonable, so if it's irrational, so sometimes, people used to have different fears that are based on conspiracy. It's irrational to stop that. So if that's the example. If you stop a speech to protect traffic, it's unreasonable. You're doing too much. You don't need to take down this whole speech just to protect this one little thing. It's unreasonable, or if it's inappropriate, unjust, if it's not predictable. If the government makes a different decision one case after another, that looks unpredictable. That makes it arbitrary. No due process. Due process means there's some kind of trial or some process before it does it. Sometimes the government needs to have a process before it restricts a right. If it's inconsistent with the goals of protecting human rights, no legitimate justification. If there's no evidence or basis. So many times the government will restrict a right and it will say it's protecting life. Like we said, if the government's protecting life, it's allowed to take big restrictions to protect life. But often the government says it's protecting life, but it's not really protecting life. This is when someone gives a speech, if some government, like a government that's a religious kind of government or like a communist government, and then someone gives a speech that doesn't follow their ideology, then the government may say this will create chaos and there'll be a civil war, there'll be violence in the streets, but there's no evidence. There's no evidence or basis that if this speech happens, there'll be violence. And if there's no evidence of violence, then it's not a real government interest. The government interest must be based on evidence. So if the government says we're stopping this speech based on national security, we're stopping violence, or we're protecting national security, if there's no evidence that it actually harms people or it will actually threaten national security or lead to a war or violence, if there's no evidence of that, then it's arbitrary. It's not legitimate government interest. The government can't restrict the right. And then judicial review. The person whose right is restricted always needs to be allowed to go to a court to contest it and say, that person who had his video taken down should be able to go to a court and contest it and make the government show evidence that if this video happened, there would have been violence. People would have been killed. So if they're not allowed to go to a court to contest it, then that's arbitrary. So if any of these things happen, then that's going to be arbitrary. The government can't restrict it. There needs to be a logical, proportional connection. So whenever the government restricts it, there needs to be a rational. This has to do with a necessity again. It has to be a rational reason to do this. Restriction has to be connected to meeting the government interest. It can't go overbroad. So sometimes the language is really open-ended. So it'll say a police officer can do anything to protect national security. Where the government's allowed to restrict any speech in the interest of national security. That's too broad. That allows an official's opinion to decide anything they want. It needs to be really, really specific. So, for example, the government's allowed to restrict speech if it will threaten someone's life. If this speech got out, someone's life would be in danger. That's a very specific reason. So the law needs to be this specific. It cannot be overbroad. It can't use too general language. Sometimes some restrictions, have to do with time. So the government may say, we'll allow your movement, but you need to allow 6 months for us to do processing for us to allow you to move around the country, or you need to give your speech to us in advance, and we'll let you give it in the future. The government can't do that unless it's prompt. It can't restrict that unless it's timely, so it can't delay too long. And then it needs to be, again, consistent with the goals of the ICCPR and other obligations, so protecting people. So anything that refers to some other human right, the restriction needs to be consistent with other human rights too. So sometimes in human rights law we hear this term margin of appreciation, and that means states sometimes can meet the human right in different ways. In different countries, they have local conditions that are a little different, but generally, or like public morality is a little different. So basically, the Human Rights Committee doesn't really talk much about margin of appreciation. It's really rare. So generally speaking, every country needs to protect human rights, and we don't talk much about margin of appreciation, but sometimes countries can have a little different conditions that we need to think about. Okay, but that's very rare. Okay, so here are some legitimate purposes. If there's a reasonable connection and there's evidence of that: national security, to protect state security; public order, public health, safety, and morals. So this coronavirus happening right now is a public health issue that makes it in the public interest. If there's an emergency, like the country's being attacked by another country, and protecting the rights of freedoms of others. So this is a list of some legitimate purposes when the government can restrict a right. Okay, so that's a basic overview of how civil and political rights work. And now let's look at a specific human right. So here, here's some individual and political rights. So some of these rights we're going to look at in class. Freedom of belief, we're going to have a class. Freedom of expression, we're going to have a class right on freedom of expression, freedom of assembly, association. We'll have a class on that. But let's look at freedom of movement. So freedom of movement is a specific human right. It's Article 12 and 13. So if we wanted to look at it, remember you look right at the text of Article 12 and 13. We need to look at the text in the ICCPR. It basically amounts to two rights. So freedom of movement, people have a right to lawfully move inside the territory and choose the place they want to live. So in the past, and in countries sometimes today, you need government permission to move to a new address. That's a freedom of movement restriction. So the government needs to have a really good reason to stop people's movement. And then also the right of entry and departure from territory. So people have a right to enter a territory, and people have a right to leave a territory. And so is it derogable or non-derogable? Can the government restrict it? Article 12.3 says there are permissible limitations. So Article 12.3 tells us this is a derogable right. The government is allowed to restrict it, and here are our four conditions again. By law, necessary for national security or public order, and consistent with other rights. So this necessary, whenever you see the word necessary, also put in proportional, necessary and proportional. So that analysis we just did on necessary and proportional, all that we just did for freedom of expression, that's going to apply to freedom of movement too. So we do it in just the same way. What's the government interest? Is it a really big interest? Are we saving lives? Or is it a small interest? It's just convenient. It just saves money, for example. And then what's our restriction on freedom of movement? Do we completely stop the movement, or do we just have people have to do an application first, something like that, a less restrictive measure? And then we do proportional. Is the burden on the freedom of movement proportional to the interest that we're trying to protect? And is it necessary? Do you have to stop this movement to achieve the goal the legitimate goal the government's going after? So here's some, and then Article 13 is just about when a foreigner is being expelled from the country. It needs to be by law and reviewable. So something like a judge needs to look at the decision when you're expelling a foreigner, and the rules have to be non-discriminatory. And so you can't treat people from different countries differently about when you can kick them out, when you can expel them, remove them from the country. And if a foreigner is expelled, removed from the country, they're allowed to choose which country they're being moved to. So you can't just remove them to any country. They need to be able to choose the country they were moved to. So freedom of movement. So basically, Article 12 applies to people lawfully in the state. So I'm a foreigner, but I have a residence card in Japan, so I'm inside Japan lawfully. But if I were in Japan illegally, that's when Article 13 applies. So Article 12 is for people inside the country legally. Article 13 is for people that are inside the country not lawfully, for some other reason. And then lawfully, the domestic law decides when you're in the state lawfully, but it has to be consistent with other obligations. So, for example, asylum. If someone will be persecuted if they return to their home state, that makes them something like a refugee. Refugees can't be arbitrarily expelled, and we'll talk about refugee law in a future class. But they would be considered in the country lawfully. Even if they entered illegally, they're still in the country lawfully because they're a refugee. They meet the case for refugee, and it's an obligation to keep refugees. Freedom to movement. Freedom to move inside a territory means you can freely choose where you're going to live. It applies to the whole territory of your state. So a country like Japan, freedom of movement needs to apply to every single prefecture. If you're inside Japan lawfully, you can move to any prefecture, any state inside there. And the right can't be dependent on the reason to want to move or stay. So your freedom to movement doesn't depend on why you're moving. In some countries, they say you can't move unless you have a good reason. China, I think, has restrictions on movement. You need government permission to move to a new address. That would be a freedom of movement problem. But sometimes China says you can move for certain good reasons. This tells us that the right isn't dependent on the reason why you're moving. The person can move for any reason they want, consistent with this right. So the basic rule is non-interference. The government can't restrict people from moving wherever they want to. So if you have rules requiring an application for permission to change residence or delays in processing it, that may be a violation. Because it's arbitrary, there's no reason for you to have an application to move because there's no good reason for it, whatever your interest is, generally speaking. And the state has the duty to protect. So non-interference means the duty to respect. The government itself doesn't stop you from moving, but the government also has to protect private people from stopping you from moving too. So here are two examples. Sometimes in some countries, women are controlled by their families, like the daughter can't move out unless her husband or her father give her permission to move. That's a private party, so the government needs to protect these women's ability to move away. Or if there's apartheid rules. So in some countries there were restaurants that didn't allow black people to come into the restaurant, or it would restrict their travel. That would also be a violation. That the government needs to stop them stopping other people from moving. Just as the government can't stop people from moving, the government can also not require people to move. It can't force them to move. So people can reside in a place of choice, and they can't be forced to displace. So there could be some good reasons, and again, remember, this is derogable. So there are sometimes reasons you can move someone. An example is if after a natural disaster, if there's been a big typhoon or a tsunami, like a big flood, where people must move because of this earthquake or disaster, that would be a legitimate reason to restrict this right. But generally speaking, unless the government has a good reason, it can't force people to move without their consent. It can't force people to move. And then free movement between countries. So a person is free to leave the country. A person is free to leave any country, including their own country, and it can't depend on the purpose or period. People have a right to a passport and documents. So without a good reason, people have a right to get a passport and to be able to leave the country. They might not have. It might be harder to enter a country, but a person is always allowed to leave the country. And aliens being expelled have a right to choose their destination, and a state can't make it too burdensome to leave. So if a person wants to really leave the country, it can't make it too burdensome with like lots of forms and really high fees and statements and an exact description of their travels. That might be too burdensome, especially for what's the government interest. And then for one's own country, if someone's your own country, Article 12.4 says, for your own country, you have a right to remain in your own country. You have a right to always return to your home country, even if you're born outside. So if your parents are from a home country, or for former refugees. And then what's the definition of your own country? It's broader than just nationality, to include any state where you have some special tie or claim to. So if your parents come from a country, that might give you the special connection where you can return to that country. Okay. Freedom of belief is another human right we'll look at really quickly. Basically, one can adopt any religion or belief or choice, and the government can never require you to believe something. So remember, that was on our list of non-derogable rights. The state can never restrict what you believe. It can never force people or tell people what to believe. Even if they believe really terrible things, the state can't force people to, it can't force them to sign a statement saying they believe something they don't believe. That would be a violation. And it's non-derogable. You can never restrict that right. But the state is sometimes allowed to restrict manifestations. So so I'll give you an example. Manifestations are practices, if a practice is integral to the religion, that's protected. And sometimes a state can, to manifest the belief, may be subject to limits under Article 18.3. So limits, again, means all that list of 4 things: by law, necessary and proportional to meet legitimate government interest. So manifestations mean practices you do to do this. And then what's the definition of belief? A manifestation has to be integral to the belief, has to be core to the belief. So here are 2 examples. The Sikh religion, and then maybe Rastafarians, or there's some religious group that said smoking marijuana is important to their religion. And then Sikhs, in another case, said wearing a turban, which is a special kind of hat, is integral to our religion. So basically, the Human Rights Committee made a decision that, yes, wearing a turban is integral to the religion, to the Sikh religion. So that means Sikh must be allowed to wear a turban. So this was a case of a police officer. Of course, police also have their special hats. This Sikh officer was allowed to wear a turban hat as a police officer. He still maybe had to put like the insignia or something on it, but he was allowed to wear a turban because it's integral to his religion. And then there was another religion, I forgot the name of it, but they said smoking marijuana was a sacrament. It was important to the religion. And this Human Rights Committee said, no, it's not really integral. Doing this drug isn't really integral. We don't believe that this is integral to this religion. And anyway, even if it were, protecting people from the health effects of drugs may be limited, may be necessary and proportional, may be a legitimate government interest. We would go through that analysis then. Another religion said, we don't believe in this government, so we don't want to pay taxes. And then the Human Rights Committee said that's not integral. You can't do that. Just as people can be allowed to, people are allowed to keep or change their religion, you can never threaten or force people to adopt a belief. So you can't punish people for the belief, and you also can't force them to have a belief. There's some rules for religious education, but we're not going to worry about that now. Here's some political rights. Of course, recognition of person before the law. For example, there have been some cases about recognizing marriage. If you're married in one country, can your marriage be recognized in another country? That sometimes comes up in gay marriage cases. That would be recognition of a person before the law. Every citizen has a right to take part in public affairs, vote. That's citizens, not foreigners, in public and participate in public administration. Okay. Here's some more rights on liberty and security of the person. We're going to look at rights. We're going to have a whole next term. If you say into the second term, we're going to have a whole class just on the right to life. That's Article 6. Article 7 is freedom of torture and degrading inhuman treatment. That will be part of our class we're going to do these two classes together. We have a special class just on them. Remember, these two are non-derogable rights. The state can never kill someone, and it can never torture someone or have inhuman treatment. Slavery was also non-derogable. The state can never put someone in slavery. That's Article 8. And no deprivations of liberty. So slavery and deprivations of liberty, we're not going to have a class on it, so here's some information on it. Deprivations on liberty is really similar to fair trial rights, so we'll look at a lot of that. But basically, the government can't detain you. It can't put you in detention unless it has a fair process. And we'll talk about more of that with fair trial. Slavery, forced labor, there's sometimes an exception for military service, civil obligation, if it's not for punitive purposes and for legitimate purposes. But basically, generally, slavery is prohibited. Here's some other civil and political rights we haven't talked about. So self-determination, we're going to talk about self-determination when we talk about indigenous people's rights. That's the ability for people to control their own government. And not have some other group that's controlling the government for you. Minorities and equality. So we're gonna have a class on racial discrimination and gender discrimination. So we'll talk about more in that class. So basically, equality of treatment and prohibited discrimination is all through all of these articles. It comes up a lot. We'll talk about that more in the future class. Civil and political rights are also very connected to protecting democracy, a well-functioning democracy, and human rights defenders. We're going to have a class on democratic space and civil society space. We should have a class just on this topic, and we'll talk about more, I think, I'll have to look back at the syllabus, but we should have a class just on this. And also, new technology is changing how civil and political rights work. So when we talk about a lot of these things like privacy and freedom of expression are now happening in the internet world, or things like surveillance. And in this online world, there are new challenges to civil and political rights. So we should talk about this in a future class as well, and in the right to privacy. So I have to also mention, aside from the ICCPR, there are two optional protocols. What's an optional protocol? An optional protocol, I mentioned before in the first class, is like a treaty inside the treaty. So this parent treaty is like the ICCPR, and then here's optional protocol 1, and optional protocol 2 is like a treaty inside the treaty. So if these are members of the treaty, these two people are members of the ICCPR, but not a member of the optional protocol. This third person is a member of the optional protocol, but also a member of the ICCPR. So basically it's like a little treaty that adds obligations to the ICCPR. So optional protocol, and we see 116 parties. So a lot of them join this. 87 parties have joined this one. That's about half the countries. So a lot of countries have joined these two. The optional protocol 1 creates an individual complaint or communication mechanism. So that means individuals can actually give a complaint to the Human Rights Committee, and the committee will accept this complaint and do a commentary. They'll give some kind of decision on this individual complaint. It's sent to the Human Rights Committee about the violations, and the Human Rights Committee decides if there's been a violation, and it can write recommendations how the country should address these violations. So this is an individual complaint mechanism. Why would a country adopt an individual complaint mechanism? Well, one reason is if a government wants to protect these rights, for example, a government may worry about future governments wanting to backtrack on rights. And so it doesn't trust government officials deciding what's a right. What's good about an individual complaint mechanism is the government isn't responding on the rights. Remember in our last class we talked about the UPR process. Every 4 years a government needs to give an account of how it's following the rights. But it can be biased when it gives those accounts. What's good about an individual complaint mechanism is private people are telling about when there's been a violation, and private people are less likely to be biased. They're more likely to give an accurate answer to if there's been a violation. So that's what's really great about having an individual complaint mechanism. If a country like the United States has not joined this, if a country has not joined this optional protocol, then individuals cannot complain. So only the government is enforcing the civil and political rights, not individuals. And optional protocol 2 is specifically about the death penalty. It completely abolishes the death penalty, with reservations allowed only for the most serious crimes of a military nature committed in wartime. So right now, we'll talk about this with the right to life. In the right to life, the death penalty is, there's specific rules for when the death penalty can be used. Japan and the United States still have a death penalty. We'll talk about it in the right to life class. But if they join the optional protocol 2, it completely abolishes the death penalty. So let's do a discussion question. So I would really like some of you to participate in the discussion question. It would be really great to see how you're progressing and if you really understand the material. And this discussion question is going to look a lot like what your case note is going to look like. So I want us to get in the practice, I want us to get us practicing how to do these discussion questions. So when our case note happens, when we need to write that for the assignment, you'll know how to do it well. And I can give comments on it if we practice already with these cases now. So for every one of these topics we're going to go through, I want to do something that's going to look like a case note, and I want us to practice them. And where we do that is on the, this is the, This is the Learning Management Center, and you can see what I've circled in red is the forums. That's where I'm going to put the discussion questions. So on this page, I'm going to put a discussion question that we see. So it's going to be on this forum, and you can respond there. So here's the discussion question. We're going to look at the freedom of movement. So we talked a lot about the right to movement. I want you to use the analysis, the necessary and proportional analysis. I want you to walk through it for the case of coronavirus restrictions. So imagine a country's passed 2 laws. The first one is people cannot travel to another country with more than 1,000 cases of coronavirus. And the second law they pass is people can only travel to the sub-state. So in Japan, that's like the prefectures. So people can only travel to another sub-state like Hokkaido with government permission in advance. And if they move to this new prefecture without permission, they'll get a month in prison if they don't have permission. Okay, so the government has passed these 2 laws, and then coronavirus is happening in the world in this case. So our question is, this is a restriction on people's movement. People cannot travel out. People cannot leave the country to a country they want to leave to. And people cannot travel to another prefecture. So I want you to say, so it's a restriction on the freedom of movement. Is it allowed? So our first question is the right derogable? Can we restrict freedom of restriction or not? So as you know, if you just listened, and so you're going to look at that slide on that list of non-derogable rights. Is the freedom of movement on that? I will tell you right now, as we just talked about with the freedom of movement, that right is derogable. You can sometimes restrict it, but you need to have the requirements. And in these requirements, is it by law? Has a law been written? And is it necessary to, what's the government interest? So remember, with our necessary and proportional analysis, we always ask 2 things. What's the government interest? And what's the burden on the right? What is the government interest? Why does the government want to stop people with this coronavirus from moving? So it has to do with health and protecting people's lives and health. So is protecting people's lives and health from this virus a big interest or is it a small interest? Is it necessary to help protect people from this virus? Is it necessary to restrict their movement? What is the actual burden on the right? What is the actual burden on their movement? Is it necessary to protect people's rights to have this burden? And then is it proportional? So to protect people's lives and health, do we have to restrict people to this extent? Or can we protect people's lives and health without having to go this far? So I want you to do maybe a little proportionality analysis. So just like we talked about with freedom of expression case, you can do this in a really short form. Tell me if, in your opinion, do you think this law is necessary and proportional to the government's interests of protecting right to health for the coronavirus. So let's do that on the learning management page in the forum. I would really like to see some of you participate, and then I can already start giving you feedback if you really understand how this analysis works. And if you have any questions, feel free, and it can be very short, only a few hundred words, maybe a paragraph or two. You can do this in a really short way. Just answer these. I think if you just answer these questions with maybe a sentence, you can do it really easily. So if you have any questions, you can email me. My email is on the front page, the first page of the slides. And that's everything I wanted to talk about for this class. Thanks, everybody. And I will see you next week. And I will put the readings for next week, Economic and Social Rights. I'm going to try to put the slides and readings up for this class so that it will be available for you to study before you come to the next class. It's great if you read the materials before the lecture, so when you watch it, you'll understand it. Sometimes I may change little things in the readings or the slides, but after that, but it's still great to study it beforehand. And that's everything. Okay, thanks everybody. Bye.